Liability is a fancy word for fault. Was it your fault or was it the other person's fault? All too often, reporting police officers don't assess fault, meaning that they don't give somebody a ticket, they don't tell you it's your fault, and they don't tell the other car it's their fault. The jury is the one that makes its determination. The jury decides who's liable, meaning whose fault it was. So when you go to talk about fault, it becomes a very, very specific fact-driven issue, meaning what actions did you take immediately prior to the crash, and what actions did the defendant take immediately prior to the crash. And the jury is then, after they hear that evidence, is allowed to assess percentages of fault to each of your liability. The jury can say it's 50% your fault, 50% the fault of the other car. They can say it's 10% your fault, 90% the other car's fault. They can say it's 0% your fault, and 100% the other car's fault. So developing and determining what these factual issues relating to your crash are from the beginning of your case is imperative. For that reason, you shouldn't give a recorded statement after the crash, especially if you're taking any type of medication that would affect your ability and your memory to either understand questions or recall what happened. For that reason, insurance companies like to get recorded statements of you as soon as possible, regardless whether you're taking medication or not, because they know that this specific facts, how much time passed between when you saw the car brake until it hit you, what you could or couldn't observe, is the exact factual issues that if you go to trial, a jury is going to make determinations of liability on. So, for that reason, if you think that you have an issue relating to liability in your car crash, or even if you don't, I suggest you contact an attorney as soon as possible to discuss those facts. Obviously, contact me anytime free of charge, and anything that we discuss be confidential in nature.